So the last step in today's session will be a change of user of land. This will be changing from residential or single dwelling to multi-dwelling. This is a common question in the past papers because it appeared 5 times from the series of 2014 all the way to 2018. So it is something that we can't afford to skip. And generally, we will begin with the law regulating the process of a change of user, and it is contained in a number of acts of parliament, namely the Physical Planning Act, the Physical Planners Registration Act, the Local Governments Act, and the Cities and Urban Areas Act of number 13 of 2011. However, it is important to note that under the new constitution, there is provision for legislation to review the law relating to physical planning. It is worthy to note that the Spatial Planning Bill is in the process of preparation by the relevant authorities, which legislation will be an added advantage to the current planning laws. This blog was written in 2022, and maybe the position of the law could have changed. We will confirm. In the context of change of user from residential or single dwelling to multi-dwelling, the process involves the initial application and approval stage at the local authorities and the final approval and processing of the title at the Department of Lands. So prior to initiating the process at the local authorities, the developer is required to place an advertisement in at least 2 local dailies of wide circulation, giving 14 days notice of the intended change of user and inviting comments and or objections if any. Upon expiry of the notice period and subject to no adverse comments or objections, the developer can then submit the application at the local authorities. So before we go to the local authorities, we must understand the prior initiating process that the developer was required to do. So basically you start by telling the examiner that here is the developer, and this developer is required to place an advertisement in at least 2 local dailies of wide circulation giving 14 days. Timelines are important. So 14 days notice of the intended change of user and inviting comments and or objections if any. And then upon expiry of the notice period, and let's say there are no adverse comments or objections, the developer can then proceed to submit the application at the local authorities. So the initial stage will begin at the local authorities part. The process at the local authorities is initiated by an application for development permission. In the application, you must include such plans and particulars as are necessary to indicate the purposes of the development, and in particular, the proposed use and density, and the land which the applicant intends to surrender either for purposes of access or public purposes connected to the development. So in brief, if you are the developer and you want to approach this local authority, you must include a plan and particulars as are necessary to indicate the purposes of the development. You must give reason why you want to develop this place to a multi-dwelling apartment, and in particular the proposed use and density, and the land which the applicant intends to surrender. I saw an article saying that even the beacons surrounding that part must be clearly identifiable. Under Section 32 of the Physical Planning Act, a local authority to which a development application has been made is required within 30 days of receipt of the application to refer the same to the Director of Physical Planning for his comments. So this is where now students start being confused. So we have seen the developer taking this application. We have seen the first step was publication to 2 local newspapers. There was 14 days to be granted for any objections. No objections was received. We proceeded to the local authority. The local authority will submit an application. We gave reasons why we want to convert it to a multi-dwelling purpose. Then the Section 32 of the Physical Planning Act tells us that it is this local authority that will look at this application, and within 30 days of receipt of the application, they will refer the same to the Director of Physical Planning for his comments. In addition, referral may be made to the other related government offices for comment, including the Commissioner of Lands, Chief Engineer of Roads, Chief Public Health Officer, and Director of Agriculture. In considering such an application, a number of factors are considered, such as physical development of the area, the land reference and title, where applicable, defined location and size of the land, current use of the land, and proposed or intended user. Area zoning regulations will also be considered, and whether due notification has been made for the proposed development. So the local authority, upon receiving comments of no objection from the said offices, may issue its approval to the development application with or without conditions, or may, on the other hand, refuse to grant it approval. The Physical Planning Act requires the local authority to communicate its decision in regard to a development application within 30 days to the applicant, specifying the conditions pertaining to the approval, or in the case of a refusal, the grounds for the same. The law makes provisions for appeal in case an applicant is dissatisfied with any decision of the local authority. So if you look at this document, the name of the appellant mechanism has been omitted. It is known as the liaison committee, where you make this appeal to. Upon approval by the local authorities, is in the prescribed form PPA2, and upon obtaining the approval, a developer may commence construction within 2 years from the date of the approval, subject to obtaining a license from NEMA. In considering whether or not to grant a license, NEMA looks at both the conditions of the approval by the local authorities, i.e. from PPA2, and the proposed architectural designs. Then from there you go to the Lands Office. This is the final stage. The Commission of Lands bears the onus to approve the change of user and set the pace for its effecting into the ownership documents. At the Lands Office, the Commission of Lands receives the application and approval in form PPA2 in a correspondence file, and the work is then assigned to a lands officer of the level of Chief's Land Officer on behalf of the Commission. So from the Commissioner's office, it is sent forth a circulation letter seeking comments from the Director of Survey and Director of Physical Planning. The comments from the two directors are then brought back to the Commissioner, who then sends the Chief Lands Officer to the property. The officer compiles a ground report. With this, the property owner is then allowed to proceed with an official search to ensure every detail is in the file. The file is then circulated vertically within the Commission of Lands hierarchy as follows. First, to the Chief Lands Officer. Second, to the Principal Lands Officer. Thirdly, the Assistant Commissioner of Lands. The file is then taken for a technical approval committee, where issues pertaining to the land and its change of user are discussed and ratified. Minutes of the technical approval committee are then circulated to the Deputy Director of Survey, who forwards it to the Commission of Lands. If there are no objections relating or incidental to the application, the file is then sent back to the Lands Officer, who handles it, who then drafts the approval letter on behalf of the Commission of Lands, complete with new conditions and demands to be met. Among the conditions requested include need for new deed plans and new titles, which will call for the property to be resurveyed. The Survey Act provides for modalities to survey private land. Validation and approval of the change of user by the Director of Surveys signifies the calls for a survey of the property in question. In this case, the property owner is counselled to seek services of a registered surveyor to draw new deed plans for the property, which are then approved by the Director of Survey, who will then commission the confirmation, erection or re-erection of the beacons of the new property. The survey process has 8 stages that accumulate to approval by the Director of Survey, where also a new land reference number is issued for the property. With the resurveyed and plans complete, the applicant fills up an application form to apply for new titles from the land registrar. The applicant then surrenders the old titles and the new deed plans to the registrar, who then files a deed file. The registrar then proceeds to process new titles for the party, with the new user included and the new attendant conditions. So the back and forth process of effecting a change of user is a long, winding and tedious process that requires much knowledge and patience. Its importance consequences and ramifications for the developer, especially from the local authorities who bear the development control responsibilities within their areas of jurisdiction, is worthwhile knowing. The reason why I'm saying this will be a likely potential area to come from is that we have seen buildings collapsing last year, even if the building had been approved to a multi-dwelling apartment, and the same building resulted to death. So this could have influenced the commercial, the conveyancing examiners to set a question from the same. So maybe we can do a quick recap, then we compare with other blogs, because it appears that this one, it appears that this blog has decided to go to every angle where there is a back and forth. They have even predicted if it can be rejected, what can happen, but what exactly does the examiner want? So we will compare it with other blogs, but we must make sure that we have understood the nitty-gritties. So in this situation, we can say we have the enabling provisions. The Physical Planning Act is the main act to rely on. So we started with an advertisement in at least two local dailies, and we gave 14 days for any comment. We saw no comment. We initiated an application before a local authority. People say this local authority amounts to county government or CECMs, county executive committee members. And the process that the local authorities, we initiated this application, and in the application we attached our deed, our plans, and we gave reasons why we are changing this to a multi-dwelling circumstance. And in particular, section 32 of the Physical Planning Act, it says that an application has been made, is required within 30 days of receipt to refer the same to Director of Physical Planning for his comments. So after we made our application to the local authority, we gave them 30 days to refer this application to the Director of Physical Planning for his comments. This is also a key player in this role, in this activity. And in addition, the Director of Physical Planning will not only be the key player, but also other stakeholders like the Chief Engineer of the roads, a Chief Public Health Officer, and the Director of Agriculture will also come into play and consider the application, and their comments will be considered. Then, if they all approve, the Physical Planning Act requires the local authority now to communicate its decision in regards to a development application within 30 days to the applicant. So let's say you have been communicated, you have received the results that all these stakeholders have agreed to your change of user within 30 days. If they reject, you appeal to which body? The liaison committee. Now, upon obtaining the approval, the developer may commence construction within 2 years from the date of the approval, subject to obtaining a license from NEMA. So many students will ignore the within 2 years clause, because failure for you to start construction within 2 years, then on the third year, that approval lapses and you have to restart the procedure again. Then, failure to obtain a license from NEMA will terminate that condition, because NEMA has the capacity to demolish houses that are built in riparian lands. Okay, so this is the critical aspect of why NEMA comes even after the Director of Physical Planning has directed this document or application to you with comments. So up to that point, we have understood. Now, on the final stage, it's where the document gets complicated. The Commission of Lands bears the onus to approve the change of user and set the pace for effecting its ownership documents. At the Lands Office now, the Commission of Lands receives the application and approval in a correspondence file. Okay, so it is this Commission of Lands who will then delegate, or who will now involve other persons, where we have Chief Lands Officer, Principal Lands Officer, and Assistant Commissioner of Lands. And then the file is taken to a technical approval committee, where issues pertaining to the land and its change of use are discussed and ratified. Minutes of the TSC are then circulated to the Deputy Director of Survey, who forwards it to the Commission of Lands. If there are no objections relating to or incidental to the application, the file is then sent back to the lands officer who handled it, and who then drafts the approval letter on behalf of the Commission of Lands, complete with new conditions and demands to be met. Okay, so we can say, after we received this application from the Director of Physical Planning, we took it to NEMA for approval, and NEMA approved. Then we went back to the Commission of Lands. The Commission of Lands sent forth a circulation letter seeking comments from the Director of Survey and Director of Physical Planning. Okay, the comments from the two directors are then brought back to the Commissioner, who then sends the Chief Land Registrar to the property, and the Chief Land Officer compiles a ground report, and to an extent an official search is conducted to ensure every detail is in the file. So we can say, after we have been given this application from NEMA, we went to the Commission of Lands. The Commission of Lands decided to seek comments from the Director of Survey and Director of Physical Planning. Remember, the first director was known as Director of Physical Planning, but in this situation we are involving Director of Survey and Director of Physical Planning. So the two directors will give their comments to the Commissioner of Lands. Okay, and in this situation, the Commission of Lands will now decide to send who? The Commission of Lands will send the Chief Lands Officer to the ground to confirm. And there is a hierarchy: Chief Land Officer, Principal Lands Officer, then Assistant Commissioner of Lands. Then it will be taken to a technical approval committee. This is where the issues pertaining to the land and its change of use are discussed and ratified. And then minutes of the TSC, Technical Approval Committee, will be circulated to the Deputy Director of Survey, who forwards it to the Commission of Lands. If there is no objection relating or incidental to the application, the file is then sent back to the lands officer who handled it and drafts the approval letter. So by the time we are receiving the approval letter, we have passed across all these people. So let us look at an alternative blog to see whether there is somebody who has decided to analyze the same and put it in a procedural manner, or the key steps that are required for this process to go on smoothly. So the process of obtaining a change of user in Kenya is that any person intending to change the use of land must first start by advertising the same into local newspaper void circulation. The purpose of this is so as to give a 14 days notice to any person who wishes to object. After the lapse of the notice, if at all there is no objection or comment, the applicant should then, through a duly registered planner, make an application to their respective county governments for approval of change of use pursuant to Section 31 of the Physical Planning Act. This by way of filing a form known as PPA1, in which the applicant will be required to give his details as the owner of the property, as well as details of the property and its current use. So the forms of PPA1 is the details of the applicant, the details of the property, and its current use. This application should be accompanied by a report known as a project brief or report, which is prepared by a registered physical planner. The report should contain the development plan as well as particulars indicating the purpose of the development. So we can say that the earlier blog had omitted a report known as the project brief or report, because this project brief was prepared by a registered physical planner, and it is the one that contains the development plan as well as particulars indicating the purpose of the development. And in the previous blog, it also omitted the form known as PPA1 and its contents. Then pursuant to Section 31(2) of the Act, this application is accompanied by development plans of the subject property as well as particulars necessary to indicate purpose of the development. This report should explain how the different interests in the subject property have been put into consideration in view of the change of the use of the land. This process of preparing a detailed project brief could take a maximum of 7 days depending on the scale of the subject property. Upon receipt, this is where we are now interested in. We are not interested in the timelines. Provided we have seen we require PP1, PPA1, and we require a development plan. Upon receipt of the development application and project report, the county government shall within 30 days forward the same to the Director of Physical Planning and other relevant authorities, such as the Land Control Board, where the subject property is agricultural, and the county government, subject to the comments of the Director of Physical Planning and the relevant authorities to which the application was forwarded to, and upon having regard to such other factors such as health and amenities, may grant the applicant a development permission in form of a form known as PPA2 or refuse to grant the development permission. In case of refusal to grant the development permission, the county government will inform the applicant in writing of the grounds of its refusal, and the applicant is then at liberty to appeal against the decision to the relevant liaison committee established under Section 13. And after approval by the county government of the change of user by issuance of a PPA2, the process does not end here, as the applicant will need to have deed plans and title deeds changed. Once the applicant receives the PPA2, now this is the permission from whom? From the county government, okay? Because the county government had forwarded the same to the Director of Physical Planning. Now, we are now told after approval by the county government, the process does not end there, because the applicant will still need to have deed plans and title deeds changed. Once the applicant receives the PPA2, they should endeavor to submit it to the National Land Commission for approval. So this is why we saw a disconnect with the previous blog, because the previous blog did not show us the transition on why we were approaching the National Land Commissioner. So we are now required to submit the PPA2 to the National Land Commission for approval. The form is then circulated to the Director of Survey and the Director of Physical Planning. So at least the previous blog mentioned the two directors, Director of Survey and the Director of Physical Planning, for their comments. These comments are submitted by a licensed surveyor on behalf of the two directors. Once the comments have been submitted, the applicant will need to get a value for purposes of enhancing the land rate. Once the subject property has been valued and the land rate determined, the National Land Commission Technical Committee will approve the development, which is thereafter followed by a resurvey of the property for purposes of preparing a new deed plan and formulation of a new land reference number for the subject property, which will then be approved by the Director of Survey. Up to that point, we can say the procedure is becoming technical, but we can clarify before we get lost. We started by publication. We went to Section 31 of the Physical Planning Act, where we made an application under Form PPA1. And the particulars of PPA1 is the details of the applicant, details of the property, and the current use. And we noted that PPA1 should be accompanied by a report known as a project brief or report. And the report usually contains a development plan, and the particulars of the development plan was indicating the purposes of the development. And it is this application that is accompanied by development plans of the subject property that indicates the purpose of the development. So up to that point, PPA1 and its project brief and report plus the development plan marks the starting point. Then we gave the entity, county government, in this situation 30 days. 30 days to do what? To forward the same to Director of Physical Planning and other relevant authorities. such as the Land Control Board. Okay, so we made the application before the county government, 30 days, Director of Physical Planning and other stakeholders. The county government, subject to the comments of the Director of Physical Planning and relevant authorities, will give us permission under PPA2. Failure, and if we are aggrieved, being the applicant, we appeal to the relevant liaison committee established under Section 13. After approval by the county government of the change of user by issuance of a PPA2, the procedure will not end there. This is where we took PPA2 and submitted the same to the National Land Commission for approval. In the previous blog, we saw that the National Land Commission will give the lands officer, chief lands officer, permission to go physically to that land. But this blog takes another angle, that the National Land Commission is the one who will approve, because it is this National Land Commission who will circulate it to the Director of Survey and the Director of Physical Planning for their comments. And these comments, for them to reach out, they are submitted by licensed surveyor on behalf of the two directors. So it is this licensed surveyor who may be going to the physical ground. And once the comments have been submitted, the applicant will need to get a valuer for purposes of enhancing the land rate. Once the property has been valued and the land rate determined, the National Land Commission Technical Committee will approve the development, which is thereafter followed by a resurvey of the property. So you have the National Land Commission. The National Land Commission gave a job to Director of Survey and Director of Physical Planning for their comments. Then we can say another entity being involved is the National Land Commission Technical Committee that will now approve the development, and is therefore followed by a resurvey of the property for purposes of preparing a new deed plan, because we had submitted our deed plan, but now they want to prepare a new deed plan and formulation of a new land reference number for the subject property, which will then be approved by the Director of Survey. So the National Land Commission Technical Committee plays a critical part in that they sit down after being given this file by the two licensed surveyor who submitted their comments to the two directors, Director of Survey and Director of Physical Planning, and those directors are under the National Land Commissioner. So this is this National Land Commissioner that created this National Land Commission Technical Committee to sit down, resurvey the property for purposes of preparing a new deed plan, in formulation of a new land reference number for the subject property, which will then be approved by who? Director of Survey. So the Director of Survey is the one to approve the new land reference number. With the resurvey and deed plans complete, the applicant will then be required to surrender the old titles and the new deed plan to the registrar, who then files what is known as a deed file. The registrar will then proceed to process a lease for the property with the new user included. The applicant is then required to commence development within 2 years from the date of approval. So what are the challenges? As seen earlier, the process of obtaining approval of change user is quite lengthy and relatively costly. The applicant may therefore need to have the necessary documents ready, such as the clearance certificates for land rates, before commencing the whole process, as well as seek the services of professionals such as advocates, registered surveyors, and planners. This is the reason why we are told, once the comments have been submitted by the Director of Survey and Director of Physical Planning, these comments were submitted to the National Land Commission for approval, because this file will now go to the National Land Commission Technical Committee. Before we reach there, the blog tells us that the applicant will need to get a value for purposes of enhancing the land rate. Because if you look at the challenge, is that the applicant must have his documents ready, and failure to have a clearance certificate for land rates, it appears that the same will be a technical problem. What are the consequences of failing to obtain approval for change of use? A change of use is a mechanism used by the government of Kenya to control the use of land in Kenya. Failure to obtain a change of use therefore may lead to repossession of land by the government. In addition, the government may require the owner of the land to restore the land in question to its original condition as was ordered in the court by the court in Ocean Freight East African Limited versus S. G and another 204. Okay, so that is the repercussion of you failing to follow the procedure. Is there any person who has summarized this procedure in one step summary procedure, because we have mastered the content? This is it. So we read this through to see whether he has captured what we are looking for. The process includes an advertisement, we know, which are and recommendations from members of the public and ministries which are obtained by the county government. The application is often combined with one for a construction permit. The process involves an advertisement and recommendations. The investor, through a registered physical planner, will make an application for change of user through filing in PPA Form 1, which must be duly signed by the physical planner. The planner and the investor will then publish public notices regarding the proposed change of user in 2 daily newspapers, inviting objections from the public within a period of not less than 14 days. A site notice will also be placed on the site indicating intention to change its user within the same duration. Planning or brief report for the site is prepared by the physical planner. The process of preparing and implementing a planning brief or report provides a framework for collecting information about a site and investigating and evaluating different interests in it. The brief will explain why the change of user is in line with the policy and why it will not have any negative effects on the land and the neighboring properties. The process could take from 1 day to 7 days. The requisite fees will be paid to the respective county governments and the receipt annexed to the planning brief. The brief will then be submitted to the county government's Department of Physical Planning for approval. The county government receives submissions from the general public. The county government will then review the change of user proposal or brief with the public objections. The authority shall, if it fits, this one is a bit very shallow and mixed up because it was depending on his memory. Let us see whether there are steps 1, 2, 3, 4 where we can tick the boxes. It is sensitive. Let me use a mouse. How do you, okay, this one appears to be a summary. How to apply for a change of user in Kenya. 1. Consult a registered physical planner. A licensed physical planner helps to determine whether your request aligns with zoning laws and development plans in your area. 2. Submit an application to the county government. The application includes a letter requesting the change, ownership documents, title deed, sale agreements, a land search from the Ministry of Lands, development plans prepared by a registered planner. That's why you had to start with step number 1, a registered physical planner. Then 3, public notice and objection period. The county places a public notice in the newspapers or public boards, allowing anyone with objections to raise concerns, e.g. neighbors who don't want a noisy bar. Step 4, evaluation and approval. If no objection arise, the county government approves the application and issues a change of use certificate. 5, implement your new land use. So once approved, you can proceed with your project, but make sure to obtain any other permits. So that one appears, at least it has given a brief summary, but grossly omitted the step-and-step analysis that we had conducted earlier. Okay, let us see what this one did. Okay, for exam questions, you will not be told that there is a change of user that is being required. It will only come through a scenario. Application for change of user. Step 1, placing an advertisement, seeking the public's opinion on the proposed change of user. Step 2, the landowner shall approach a registered physical planner who shall prepare and submit an application for change of user by filing, signing, and submitting the prescribed form, PPA1, to the relevant county government office responsible for planning and use. Then step number 3, the landowner shall then cause to be published notices of intention to change user in 2 daily newspapers. A notice on the proposed change of user shall also be placed on the site in the prescribed form. The next step involves the preparation of planning report by the physical planner, which describes the framework for collecting information about the property, interrogates the interest in the property. The planning report further explains the conformity of the proposed use of the land to county and national land use policy. Step number 5, payment of requisite fees and submission of the planning report to relevant county government, physical planning department. Step number 6, County Government Department of Physical Planning and Land Use Review shall then take comments from the public on the change of user and make a deliberation on whether to approve or reject the application based on the planning report submitted to it. 7. Once the county planning office finds that the proposed changes are in line with the physical planning principles, it shall then issue its permit through PPA2. But this is where we are saying, if you read normal blogs, we saw a blog saying that once you have received PPA2 form is not final. So the only remedy that we can have, if you're also paying attention, is that you will realize that some are saying that the advertisement is to be placed by the county government. Others are saying you are the one to place the advertisement. This is the reason why we do analysis of the various acts. So one of the acts that we have targeted is it will be the physical planning and physical planning act, so that we settle this procedure once and for all. But provided we know the detailed information that happens at the back of our head when it comes to this kind of procedure, we now want to remove all doubts and stick to what the physical planning act provides. So up to this point, maybe Ringera, whether you have a comment, I will wish to end the recording, then upload the same in YouTube, and we will do SOPEC. We will start with SOPEC rules tomorrow, and then still go on with other units. I believe now with this kind of revision, we are tackling as much as we can within a short period of time. So Ringera, the floor is yours for any comment. Ringera, am I audible? Ni kama I have lost my connection.